It's important for providers to work collaboratively regarding these issues. The restrictive state laws can make it challenging for individual providers to know how to properly care for patients. So, working with their entities, legal and risk departments is important because the risks to the patient and to the provider are high.
Hello and welcome. I'm your host, Erin Sutton. I'm an attorney in Epstein Becker Green's healthcare and life sciences practice based out of our Chicago office. 23 states have passed legislation that bans access to certain forms of gender-affirming care, and another 14 states have enacted laws protecting access to gender-affirming care. Today on Diagnosing Health Care, we will discuss gender-affirming care, what it is, what it isn't, and what is at stake for providers and patients. Gender-affirming care has become the latest flashpoint in state legislatures and state and federal courts across the nation. States are divided by either passing laws that seek to restrict access to gender-affirming care or laws aiming to protect access to gender-affirming care and the healthcare professionals who provide such treatments. Our conversation will take a deeper look into what gender-affirming care is and understand how healthcare providers and patients seeking to provide or access this care have been affected by the current volatile legal landscape. If you like what you hear today, please subscribe to the show. Diagnosing Healthcare is available wherever you get your podcasts.
Welcome to Diagnosing Healthcare, a podcast featuring thought-provoking conversations about the latest legal, policy, and regulatory issues in healthcare and life sciences. Brought to you by the lawyers at Epstein Becker Green.
Joining our discussion today is Jenny Nelson Carney, a member of the firm based out of EBG's Columbus office. Lately, Jenny's practice has included counseling and education on laws restricting or protecting gender-affirming care. Hi, Jenny. Thanks so much for joining us today.
Thanks, Erin. I'm really happy to be here.
Also with us today is Lisa Pierce Reisz, a member of the firm, joining us from the Columbus office as well. Lisa has recently tackled questions related to privacy and security of patient health data related to gender-affirming care. Hi, Lisa. Thank you as well for being here.
Thanks, Erin. Happy to be here on this important topic.
It might be helpful to start with a bit of background on what exactly we mean when we say gender-affirming care. Jenny, as you know, gender-affirming care is an umbrella term covering a range of different medical interventions used to support gender-diverse and transgender individuals when there's a conflict between the individual's gender identity and the gender they were assigned at birth. What can you tell us about gender-affirming care, and what might this include for minors in particular?
Well, you're exactly right when you say it's an umbrella term. It's important to think about gender-affirming care as a supportive form of healthcare. And I think there's often a misunderstanding that gender-affirming care is just a surgical procedure, but it's really broader than that. Though we should note here that gender-affirming care may be defined by state law and thus may look different in different states. But we'll speak here about how the healthcare industry typically defines gender-affirming care. Gender-affirming care includes things like social affirmation, which includes changes to appearance and pronouns. It also includes things like medications, which people hear a lot about in the news, such as puberty blockers and hormone therapy. Surgical procedures are a part of gender-affirming care, but it's not everybody that is seeking gender-affirming care is necessarily looking for a surgical procedure, but that is one option. And then a fourth component is the legal affirmation, which is things like changing one's gender or name on legal documents. So as you can see, there's a wide range of gender-affirming care, and some forms of gender-affirming care are easily reversible, like social affirmations. Others, such as the surgical procedures, are not. Gender-affirming care for minors involves the minor, their parents or guardians, and medical professionals making decisions together about care for the minor. And no permanent medical interventions happen until a transgender person is old enough to give informed consent. Typically, prior to puberty, gender transition is largely social, which might include changing names, pronoun, clothing, hairstyles. And then during or after puberty, some medical treatments may be available. It's important to keep in mind that there are approximately 2 million Americans who are transgender, and 1.6 million are 13 and older. So that gives you a sense of, we see a lot of minors who are transgender, and there's just a lot of need in this country for gender-affirming care. In addition, research has indicated that transgender individuals without gender-affirming care face increased risk of anxiety, stress, substance use disorder, and suicide. And it's important to note the provision of gender-affirming care is widely supported among medical associations and within the healthcare industry.
Thank you. That was very helpful. Why don't we talk about the state bans and protections on gender-affirming care? As we've already hinted at, there's been a lot of activity in state legislatures banning or protecting access to gender affirming care, and just as much activity in state and federal courts challenging these laws. The U.S. Supreme Court only recently issued an order allowing an Idaho ban on gender affirming care to take effect. Jenny, can you describe what is happening in the states with restrictions on gender affirming care? What is being restricted, and how are these restrictions varying in court?
So we're seeing a lot of state legislative activity on this issue, especially as related to care provided to minors. In addition to legislative activity, we've also seen restrictions through rulemaking and governor's executive orders. And generally, what we see is two categories of restrictions: restrictions on medication and restrictions on surgical procedures. Just under half the states have some sort of ban on medication and or surgical care for transgender youth. The last number that I saw was 24 states. We also see restrictions such as the imposition of professional or legal penalties on healthcare providers providing minors with gender-affirming care. And I recently saw a number that suggested we had 22 states that fall into that category. But this is certainly a very active area of the law. And so we're seeing new legislation proposed pretty frequently, especially in the more restrictive states. It's important to note that there are a handful of states which make it a felony crime to violate their restrictions on gender-affirming care. And opponents of those laws are arguing that criminalizing gender-affirming care for transgender youth is just a politically motivated issue and is not actually tethered to evidence-based medicine. So they're continuing to fight those restrictions in the more restrictive states. On the flip side, we've seen some states enact shield laws to protect access to transgender health care, and we've seen that in 14 states plus the District of Columbia. Clearly, tons of activity, tons of legislative activity throughout the country. We've also seen, as Erin mentioned, litigation surrounding some of these legislative changes. Right now, we have about 17 states facing lawsuits challenging their laws or policies limiting youth access to gender-affirming care. And much of this litigation is still pending since it has been filed so recently. So much of this legislation has been within the last few years. And so the litigation surrounding the legislation has been largely filed in 2023. And then we've had some new cases in 24 as well. So a lot of it's still pending. As Erin mentioned, the U.S. Supreme Court recently allowed Idaho to proceed with broad enforcement of a new law aimed at prohibiting gender-affirming care for minors as litigation over that law's constitutionality continues. The court did, however, allow the parents and two children who brought the case against the law to continue to obtain treatments during the litigation. So while the ban is there, the court said, okay, for these plaintiffs, they can continue to have treatment while this litigation continues. So we're seeing, like I said, a ton of legislation and then significant litigation over the legislation, and we would expect that to continue over the next few years.
That's definitely a lot of activity. Lisa, do you have anything to add?
I'd like to echo a lot of what Jenny just said, but in my view, one of the most important things she talked about is the fact that gender-affirming care is healthcare. The activity that we have seen over the last 2 years really has come on the tails of what has happened in the reproductive healthcare arena after Dobbs. And a number of these banned states are taking some of those actions, sort of that playbook. And we're seeing this sort of as the new frontier from a provider standpoint. You have providers that are taking an oath to take the best care of their own patients and then are winding up in this really threat environment of their license, criminal penalties for providing what they believe is in the best care of their patients. And then you've got patients, their families being targeted with abuse charges and other things. So it's an area that's really fraught by a lot of damage to providers, damage to families, and certainly damage to these very vulnerable youth. It's interesting that we have evolved to this, frankly, after Dobbs, and this is sort of the next frontier.
I totally agree with that, Lisa. And I was actually just talking to a physician this morning that said to me, no offense, but I'm so frustrated that I have to speak to a lawyer before I can determine what kind of care to provide to my patient. And I just thought that was such a concise and direct statement about the problem with legislators legislating healthcare specifics.
All great points. And it's really quite a radical departure from how we even think about governing the practice of medicine. A profession is meant to be self-regulating. So it's just so interesting to have state government defining medical terms for then medical professionals to have to interpret. It's quite a unique time. And I know there's been a lot of questions that abortion was first, reproductive health care. Now we're dealing with, another offshoot of gender-affirming care. And what's after that? What might the next controversial medical or politically influenced medical procedure be that gets swept under this sort of style of legislating medicine? It's probably important to talk about privacy considerations, given all of that. Let's talk about the privacy considerations at play. Whenever medical treatment becomes controversial, as we've talked about, patient medical data is going to be at the heart of any investigation against a provider, a hospital, or a health system. But this information has protected status in certain contexts. So, Lisa, how might states try to access this information? And are there any protections for patients related to gender-affirming care?
Erin, it's a great question. And I go back to sort of healthcare 101 and provider ethics 101. Traditionally, for 100 years, patient information has been protected and it's confidential and it's considered that way. You talk to anybody, that is their expectation. And yet in this arena, we're sort of at the mercy of the tools and the technology that we now have, in addition to the old tools that folks used to have to be able to frankly, obtain data and access data. And so, at this crucial time as we're dealing with gender-affirming care and the bans and the access barriers that we're seeing, data is going to be, I think, one of those places where government is going to try to access and use it, frankly, against patients and their families and their providers. In Indiana, the AG went after transgender data under the consumer protection statutes in that state. And a couple of providers there responded and said, we can't respond based on either HIPAA or state privacy laws, and push back. And if you look at traditionally what courts do when providers have pushed back on providing data, either under HIPAA or something else, most courts will at least fashion what can and can't be disclosed to AG's office. A lot of times they'll say it's got to be de-identified. They will narrow the scope. At the very least, any provider that is met with a state request, it may look valid, it may be valid, but there probably is very important patient privacy pushback that should be done in response to that, to at least narrow a request to make sure you don't have individuals whose data might be at risk. That is one way a state can go after data, and it's typically through those AG requests. And they rely on some exceptions to HIPAA, which are there. But if providers are really looking at HIPAA carefully, first of all, HIPAA exceptions say a provider may, but does not have to unless it's required by law. So they can either say no, or they can push back and say, not in that instance, or we're going to narrow that or do those sort of things. The other ways I think that we're seeing state involvement, and they're basically with regard to some of these digital footprint issues, when you look at what is out there, and unfortunately, there is still not a national privacy law. We're seeing a patchwork now of state laws, but folks can get after your digital footprint. Through a geofence warrant, law enforcement can go and get a warrant for your digital footprint, your digital communications, your geolocation. For instance, were you near a clinic? Can you tie all of these pieces together? So the technology in these states could make, again, this very vulnerable population even more vulnerable based on their own digital footprint. And we're seeing it. We're seeing states pick up that data, keyword searches, again, geolocation services, and just sort of what are your search things? And they're using the big technology companies that already have so much data to put these things together. We haven't seen prosecution yet, but look at the Texas AG. He's even looking out of state to prosecute folks and get information for folks that traveled and then are trying to come back. So it's unclear where this is going to go so far, but the privacy considerations and the data that's out there really could be a danger and a risk to providers, their patients, and their families.
Lisa, you raised a lot of really interesting aspects of this issue. And I wonder what you think about, I know at least in the abortion context, states are required to report de-identified abortion information as a part of their, healthcare facility or provider reporting requirements. And the Indiana AG has actually argued that that information shouldn't be de-identified. It should be freely available because it's not, in his opinion, considered healthcare information. What do you think of that sort of argument? Do you think it could be applied or attempted to apply to gender-affirming care?
Erin, it's a great question. And again, I see the gender-affirming care as being the next step past Dobbs and the abortion care issue. I absolutely see, and we saw it in a couple of these other states, for instance, in Texas as well, where they are seeking literally not de-identified, but the names and healthcare information, sometimes even photos for these patients that are undergoing this treatment. As a privacy matter, every healthcare provider should be at least looking to potentially push back to protect their patients. At the very least, they should be asking whether the information requested is the minimal amount required for the government's purposes. And Erin, to your point, for anybody to say that reproductive health care is not health care and therefore shouldn't have the same protections under HIPAA or state law that other data should have, I think that's a pretty far stretch for how we've always treated healthcare information. But yes, I do see state AGs and other investigators going after that data under that same type of argument.
It's probably a good idea to talk about some of the practical considerations, and you've definitely already hit on them, Lisa, with tactics or ways to respond to requests like these. But Jenny, what are the day-to-day issues providers are facing with the controversy surrounding this type of care? What are the practical considerations that healthcare facilities and providers should be aware of?
Good question, because it is presenting a lot of challenge. And I should say what's happening in the law is creating a lot of challenge. So I would say that the biggest challenge right now are just understanding the legal changes. Because these new laws are rarely written by clinicians, they are not easy to interpret or apply to clinical care. And so when we're speaking with clinicians who are frustrated with how a new law or regulation or executive order impacts their practice, and they say, I'm so frustrated, this doesn't make any sense, or this is how this gets in the way of the good care that I know this patient needs, in the direction we need to go with their care. We as lawyers apologize on behalf of these laws and say, I understand your frustration and I'm sorry that you're having to deal with these. The reason that they are not easy to understand or apply to your practice is because they're not written by people who are doing what you're doing. So unfortunately, that means that the clinicians need to work closely with their legal departments and potentially their risk departments as well to help them understand the new laws in the states in which they practice and what that means for their day-to-day practice and care of patients. In addition, continuity of care is a significant challenge. Providers in the restrictive states are challenged to work through what kind of care they can provide in the gender-affirming care space and how to care for patients when they can no longer provide that care. You may have patients who are mid-treatment when a new law passes that says that you can't provide that type of care anymore. And hopefully there's a grandfather clause at least that says go ahead and continue with patients currently receiving care, but we've seen states that don't have that. And so you need to figure out how to care for those patients in the safest possible way. And potentially that's a referral outside the state. If you're allowed to do that, we have states that are trying to prevent clinicians from referring patients to other states for gender-affirming care, just like we saw with reproductive care and continue to see. And so it's important for our providers to determine what constraints they have when they realize that they can no longer provide the type of care that their patient needs. Another area of challenge that we're seeing is in the area of insurance. Obtaining malpractice insurance has become a significant barrier to offering gender-affirming care. Some carrier policies actually exclude coverage of gender-affirming care for minors. So that is quite the challenge for clinicians in this space. If there is insurance available, another barrier is that those policies tend to come at a very high cost. And we've seen premiums that are 4 to 5 times what you would typically expect for a clinician providing patient care. So that is a significant challenge to our providers. Communications is a huge area, both internal and external communications. The internal communications look like, how do we explain to our clinicians and workforce what the new laws are, how to manage them, and how to deal with our patients in the most safe and appropriate way. But external communications may be an even bigger challenge. What we're seeing is providers trying to determine how to communicate to the public what services they provide without becoming a target for anti-gender affirming care activities. We've had many providers that have been subject to online and offline threats and harassment. And so they have made the difficult determination to limit their public-facing references to gender-affirming care. Even if they're still able to provide that care, they wipe it from their websites or make just veiled references to the availability of that care, which is very unfortunate that healthcare providers cannot be upfront about what care that they have available to patients that need them. So we're seeing a lot of challenges in that area. Lisa, I know you're seeing other types of administrative hurdles as well. What are you seeing?
Yeah, Jenny, I think those are such great examples. And the one thing that I guess especially from the data privacy side, it's the same thing we tell all of our providers when they receive any type of subpoena or other legal process. I think everybody gets really nervous and they're like, we've got to respond, we've got to do this, as opposed to being very thoughtful about, frankly, who it's from, what they're asking for, and what really should be the thoughtful response given the ethical obligations and the confidentiality obligations that they have under HIPAA and state law. And when it comes down to this information, it really is, to the extent it is individualized, it is protected health information that is governed by HIPAA and most state laws as well. And they should not be bullied by some of these AGs and others. I'm telling our providers, the ones that I work with, stay focused on your patients, stay focused on your obligations, and do not just send records. A lot of times you respond politely, you potentially file a motion to quash, but there is no response that is required under HIPAA or state law. At other times, you negotiate the response either through de-identified records. And if we still don't agree, then you go to the court and say, if we turn these over, we're in violation of our HIPAA obligations, our ethical obligations. We really need to thoughtfully analyze this. So once again, you are providing the best care to your patients with the obligations that you have.
All great suggestions, and definitely gives a lot of context to the issues that you've been dealing with, both of you, on the ground and talking to providers and the actual folks at the heart of this controversy, the physicians, providers, and patients who are just trying to access or provide this care. We've covered a lot of ground in our discussion today. So to wrap up, if listeners have one takeaway from today's podcast, what should it be? Jenny?
It's important for providers to work collaboratively regarding these issues. I think you heard that theme in much of what Lisa and I had to say today. As we mentioned repeatedly, the restrictive state laws can make it challenging for individual providers to know how to properly care for patients. So working with their entities, legal and risk departments is important because the risks to the patient and to the provider are high.
Lisa?
My takeaway is at the heart of this is healthcare. As Jenny alluded to, it's really difficult when our providers, as they say, have to go to legal before they can provide care. And that's kind of the reality in some of these states at this moment. But I think having a plan that, you know, the law, you try to take the position you can to give the best care. And as Jenny said, probably having a plan to send somebody to a different state where you need to be able to get that care. I think we have to find solutions to allow them to best serve their patients in a compliant way, but in a way that gives solutions.
Great. Thank you so much, Jenny and Lisa, for taking the time to participate in today's discussion on gender-affirming care. And thank you to all of our listeners. I'm your host, Erin Sutton. If you like what you heard today, please don't forget to subscribe. Diagnosing Health Care is available wherever you get your podcasts.
Thank you for listening to Diagnosing Health Care. For show notes on today's episode, additional episodes, and more insights on trending issues in healthcare and life sciences, please visit diagnosinghealthcare.com and be sure to subscribe on your preferred platform. This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.